Hi everyone, my name is Erin Hayes. I am the Legislative Director of the Racial Justice Coalition of Texas. Our mission is to get the Racial Justice Act passed in Texas. The Racial Justice Act allows individuals on death row to downgrade their sentence if they're able to show that racial bias was a significant factor in any aspect of their trial, including the prosecution's decision to seek the death penalty, jury selection, and jury instructions, anything of that sort. We're also looking at using statistical evidence to be able to help these individuals lower their sentences. Today, we have Ms. Gretchen Engel with us. She's the Executive Director of the Center for Death Penalty Litigation, and we're really excited to have you here today, Gretchen.
So I went to law school wanting to work on issues of racial justice and was interested in how racism and poverty were my main concerns. And so those are really brought together very vividly in the death penalty. And so I did an internship with Bryan Stevenson, who's the founder of the Legacy Museum and Lynching Memorial in Montgomery. This was in the early 90s when he was working at the Alabama Resource Center. Doing death penalty work. And the first case he sent me to work on was an African-American man who was on death row for the murder of a white woman. And at trial, the prosecutor had used 20 of 21 peremptory strikes to exclude African-Americans. My introduction to this work, and I was lucky enough to land a job in North Carolina in 1992. And one of my first projects there was helping one of our iconic civil rights lawyers and later RJA, Racial Justice Act litigator, James Ferguson, with a presentation he was giving on discrimination in jury selection. And at that time, that was 6 years, I think, after the US Supreme Court had made a very strong statement in Batson versus Kentucky about discrimination on the basis of race in jury selection. And as of 1992, our courts had never found discrimination against Black people in jury selection. And 28 years later, that record is the same. They've upheld trial court determinations there was a Batson violation against white people. 2 cases of that. But it's an incredible record and was one that we talked about, more than 10 years ago when we were looking at passage of the Racial Justice Act, in large part because we said, look, after McCleskey, the case where the US Supreme Court said statistics, we're not interested, you cannot establish an 8th Amendment violation through the use of statistical patterns of racial disparity, even though we have no question that you're right about those patterns. And so when we went to the legislature, it was with, look, McCleskey has set this arduous standard that no one can meet. And Batson, the same thing, equally onerous. And we know anecdotally, certainly, that race plays a role. And we want to have an opportunity to explore that with statistical evidence, which the RGA gave us that opportunity and of course confirmed what we had suspected.
Right, and that's exactly what we're trying to do in Texas as well. So I wanted to talk a little bit about your position with the CDPL. We wanted to know what your day-to-day work is like at the center.
So we largely represent post-conviction death row clients in North Carolina, state court, federal court, through clemency proceedings. We've had de facto moratorium on executions since 2007, so 14 years. We've had no executions in North Carolina, largely because of litigation led by our office around the Racial Justice Act and also lethal injection and challenging the procedures for that. And we have to do some trial work as well. We have a public education arm that works with our litigation teams to tell the stories of our cases. And I think that's one of the real successes of the Racial Justice Act litigation is that I think we've really been able to help the public conversation around the denial of citizenship, basically, to Black jurors and to really acquaint people with the flaws in the death penalty. And so we're an advocacy organization as well as a litigation law firm.
What kind of things are you guys focused on right now with the RJA or besides the RJA?
So we are in our second decade of RJA litigation, and the statute was originally enacted in 2009. Everyone filed in 2010. We had some hearings in 2012. The statute was repealed in 2013. And just this summer, the North Carolina Supreme Court said that the repeal could not be applied retroactively. And so we've got favorable rulings in June that basically put approximately 130 of our death row back to square one, where they were in 2010, having just filed their RJA motion. The thing that we're working on most intensely now is sort of getting organized to figure out, okay, how are we going to litigate 130 cases? Does it make sense when, this is different from if you had a statute about exempting people on death row for severe mental illness, for example, or prior to the Atkins decision for intellectual disability, where there each client has his or her own unique facts, which his or her individual team would investigate and present. Whereas here, because a major source of our evidence is statistical evidence, we're all using the common study that Michigan State University carried out. And our RJA provides for relief if you can show statewide discrimination. So from our perspective, the most efficient way to do this is to have a small group of cases be litigated that are representative of the entire row and litigate the statewide discrimination claim and get out, what is it? Here's our study. What does the state have to counter it? Is it a reliable study? Is there additional historical and documentary evidence that we can add to that showing? And so it's kind of getting organized for the next phase of litigation. And also figuring out what the state's position is on this, because obviously we are in a moment now that is very different from where we were even 6 months ago, right? In terms of public attention and public understanding of racial bias that is pervasive in our criminal punishment system. And so I think there's a real question for our Attorney General of, how hard am I going to fight against this litigation? If I look at this study that the defendants are going to present, do I really have anything to say to counter that?
What cases have you litigated so far, and how did they turn out?
Well, so interestingly, when everybody filed in 2010, and that was 153 prisoners on death row out of 158 filed.
Wow.
And we at that time proposed to the state and to the Conference of District Attorneys, let's do a coordinated litigation. Let's, get together and think about what are the cases that make sense and common issues, and perhaps agree on a judge that we both think it can be fair and that we have confidence in. And at that time, the state was not interested in pursuing that. And so we ended up litigating 4 cases in Fayetteville, North Carolina, which is Cumberland County. It's the home of Fort Bragg and the 82nd Airborne for those outside the state. And this was a county that had a large number of people on death row, a large number of Black jurors who had been excluded from those trials, and a chief resident judge who was really a respected, scholarly judge. It was very respected throughout the state. When Michael Jordan, the basketball player's father, was unfortunately killed in North Carolina, and 2 young men were charged with that murder, it was Judge Weeks that was assigned to preside over that trial. So I think that gives you some sense of that this is a person that his peers certainly recognized was a good judge. And so we had one defendant named Marcus Robinson went to hearing in the end of January of 2012. He won he had a 2-week hearing, lots of evidence, both statistical and non-statistical. Won and was resentenced to life without parole in April. At that point, our legislature came in and amended the Racial Justice Act and tried to narrow it, got rid of the statewide evidence as a basis for relief was one of the changes they made, and made everybody file amendments that would conform with these new statutory limitations. And we did that, and 3 more Fayetteville defendants had a hearing in October, another 2-week hearing. That hearing was actually more about the cross-examination of the prosecutors and a focus on their actions in these defendants' cases and in other cases in the county. We also introduced the statistical evidence, of course, but the legislature had said you have to show discrimination in your own case. So that hearing was actually much more personal and more adversarial in a way, because it was less emphasis on the statistical evidence and a more holistic kind of presentation. All three of those clients also won in December of 2012. So by 2013, the legislature again passes a repeal bill, and at that point, new governor signs it, and the statute is repealed. But those two hearings really, I think, produced some very disturbing evidence, right? In addition to just I haven't even said, right? So what the Michigan State University study showed is that Black citizens, when they come to the courthouse for jury service in capital cases, and this is looking at from 1990 to 2010, more than 170 capital proceedings, that if you're Black, you are twice as likely to be excluded by the prosecutor than white citizens. Let's look at all the people who express some hesitation about the death penalty, which of course would be a very legitimate reason, right, to exclude somebody in a capital case. But if you take all the white people and all the Black people who say, well, I'm not such a big fan of the death penalty, or I'm not really sure, or is not a fervent death penalty supporter. If you look just at them, there is still a strong differential, and Black people are much more excluded. Same with, if you look at people who say, it would be a hardship for me to serve on a jury that in a trial that might last 2 to 4 weeks. Same thing if you look at people who they or their family member has been involved in the criminal legal system. Race continues to be this strong factor at approximately double the rate your chances of being excluded from jury service. And we found, training materials that prosecutors were given a list of kind of prefabricated reasons that they could offer if the defense suggested that they had excluded somebody because of race, and they could just read off the list a reason. And we had transcripts showing that had been used.
Right, and it's a low bar. I mean, it's like, he looked at me wrong, he had 2 rings on his finger. I mean, it's such a low bar to show that there was any other reason other than race that they struck a Black juror.
We also had found jury notes that were very disturbing. In one of the cases, the venue had been changed, and so the prosecutor went down and met with local law enforcement and took the summons list and made notes, 6 pages of notes, the heading of which is jury strikes, right? These are the people I'm going to get rid of. And there are comments about different jurors like Black wino or thug. And then in contrast, there were notes sometimes about a white juror that said, country boy, drinks a lot, okay. And I think the one that I found most sort of reprehensible, and Bryan Stevenson was one of our witnesses, and I think this particularly bothered him as well, was there was one woman where it was noted that she was from a respectable Black family, as if that were a remarkable thing. That was worth writing that down. There was at the end of the notes a list of neighborhoods to avoid, all predominantly Black neighborhoods. And of course, we live in a very racially, residentially segregated country. Some of the jurors were marked with that neighborhood, right? So there was a woman named Shirley McDonald who had no history of any kind of criminal activity. And yet the note by her name is Black, high drug, because she lives in a poor, predominantly African-American neighborhood. So this was all powerful evidence, and the judge was convinced by it, and so reduced the sentence of those defendants.
So was this study a study that the Center for Death Penalty Litigation did, or did you just use it? It had been done previously and you used it for the purposes of looking at the statistical data?
So we asked these researchers at Michigan State to do the study, Catherine Grosso and Barbara O'Brien. They had worked previously with David Baldus. David Baldus is the Baldus study that's in the McCleskey case. And so they had studied with him a study of this magnitude, because I've been talking primarily about jury selection, and that's what we focused on for the litigation. But the RJA also forbid, as your proposal does, discrimination in charging and in sentencing, other decisions that the prosecutor or the jury is making. And so MSU also looked at all of that evidence, and no study had ever been done in the very compressed period of time that we were given by the North Carolina legislature. They said, if you're on death row, we're enacting this statute on August 9th, 2009, and you've got a year to file. And so they had to, we had to do all that data collection and get the results and analyze it and get affidavits and prepare sample pleadings, distribute those to lawyers throughout the state so that they could file on time. So it was a massive effort. And we were so lucky to have these researchers who just were willing to put in the time. And
so why do you think it is that the legal system is typically really resistant to the use of statistical data?
Well, it's interesting. I mean, I guess I feel like people are very selective about arguing against statistics. I mean, we use them all the time, and they're used by, the ads you get on your phone that are personally calculated to you they're based on statistical algorithms, right? The placement of products on whether they're low down or eye level at target is based on statistical patterns, and we use it in public health and environmental dangers and all kinds of other things. I think, generally the advantage, of course, of using statistical evidence, and this is something that the North Carolina Supreme Court commented on in its two recent decisions about the Racial Justice Act, was in an era where, and of course, we're talking about pre-2016 here, where most racial bias is covert rather than overt. It's only revealed through these statistical patterns, right? Because people don't usually say, and like they did, we have cases from the 90s where people said, I already had a black juror, and the defendant was black and she was black, and I already had a black juror. So, okay, what could be clearer? But where people are, as you mentioned earlier, where they're saying things like, well, I don't know about the jewelry that person had, or that person had a t-shirt, or that person didn't call me sir, or didn't look me in the eye. We can make sort of we might have thoughts about, does that sound kind of like a proxy for race, or, negative experiences with the police? Certainly that correlates with race. But having the hard data that shows case after case, when you control for different factors, Black people are subject to being dismissed from jury service at twice the rate of whites. Well, it is what it is. And so it's really not a new idea that we would rely on statistical evidence. And I guess I feel like, when people, then their comeback is, well, there's lies and then there's statistics. That's about, we don't like what the data show.
Well, now I'm going to kind of shift gears to Texas and our efforts. So what are some challenges that you expect us to face, and what advice do you have for us to overcome them?
So,
because there's going to be a lot of challenges.
Yeah. There's pros and cons, right, to having it focus strictly on death penalty cases. There's a good argument, right? It's the most harsh and severe and irrevocable punishment. And so we should have the most heightened standards of reliability in those cases. At the same time, they're the most emotional cases. And so, part of our decision to focus on jury discrimination was, we thought Black citizens called for jury duty are much more sympathetic. And if we focus on litigating, charging, and sentencing, we're going to be spending a lot of time talking about the facts of our clients' cases, which are horrifying, right? People find them very upsetting, and everyone, all of us would do. The accusation that this is a backdoor way of getting rid of the death penalty, that's an argument we heard before the RJA was passed and have heard in the ensuing decade, which I always felt like was kind of a confession, right? It's like, well, what do you mean? Are you admitting that it's racially biased? Are you like the McCleskey court that just says, well, it's inevitable, right? I mean, that's why that case is the Dred Scott of our time, right? Is that sort of indifference to racial injustice.
Right.
You know, I would say in general, and this was something that Bryan Stevenson testified about, is anytime you have any forward motion in the battle for racial justice, you have resistance, right? And whether that resistance is, you know, people lining up and spitting on school children who are integrating schools, or pushing back on voting and trying to suppress the vote, or responding by, you know, saying, oh, you just turned up these really racist, disturbing notes and these really clear statistical patterns. Well, we're going to repeal that statute. I mean, that's the same story. And so I think you're going to see that.
Was there specific language in the statute that got a lot of pushback? I'm assuming so, because it was amended later.
Right. Well, I think the statewide claim and the use of statistical evidence is what really got people's attention. And then, you know, it's interesting. I mean, I understand, and as somebody who's been done death penalty work for a long time, right? It's only in recent years, as we're working more in coalition with other partners who want to see criminal reform of the criminal punishment system, that we've had to sort of go through, for example, our website and get rid of all these references to life without parole, because these other groups are like, we're not supporting that. That's death by incarceration, right? Whereas for us, you know, somebody who came through the 90s and, you know, in the fall of 2003, we had 7 executions in North Carolina starting in August.
Wow.
That first client was my client, and we just every 2 weeks killing somebody else. You know, the idea of encouraging people to plead to life without parole so as to avoid the death penalty, I mean, that's really ingrained. And I think for so long we sort of touted life without parole as the alternative that will keep society safe, but it's not irrevocable and it's not the death penalty. And so I think some real thought about the messaging around that. We did not get life without, and I know Texas was a latecomer to life without parole as well. We got life without parole in '94. And so we have a large, you know, a fair number of people who were sentenced before that, or their crimes were before October 1, '94. And so they were the people that had to sign a waiver to say, I'll accept life without parole. That was something that was in the amendment. But what the prosecutors did when the RJA was first passed was said, well, you know, you can't give them life without parole. They're going to be getting out. I mean, that was their big public message, was that thanks to, and they actually had a mailer, an election year mailer that they sent out with pictures of 2 death row inmates saying, thanks to Senator Holloman, one of these 2 murderers could be coming to your neighborhood to live next to you. Now, the irony was that one of those prisoners, Henry McCollum, he actually is out. And you know why? Because he's innocent. And he spent 31 years on death row. And that was, I should have mentioned earlier too, you know, something else that really fueled the passage of the Racial Justice Act was the number of exonerations we had of African-American defendants who were convicted by all white or nearly all white juries. And some of them came to the legislature and supported passage of the RJA. And that was a powerful image for people to see, and something that was hard to argue against, right?
Right. I'm not sure if you're aware of Rodney Reed. He's an individual.
Yes, yes.
So we're working really closely with his family. They're one of our coalition partners, and
great.
They've been helping us a lot. But we love Rodney. We think he's just a wonderful person, and we think, in the horrible case that he does not get out in February, we think that the Racial Justice Act could help him tremendously. We think it could have helped him had this it's not come out. So, I mean, that's a great point about Innocence, because, in one way we want this to help, people who are not innocent, because racial bias affects them too, and they don't deserve that.
Right.
But on the other hand, there are people on death row who are innocent, and the Racial Justice Act can be used as kind of an emergency brake to say, hey, wait, there's evidentiary issues in this case, there's innocence issues, but also there's this racial bias issue that has to be addressed, because Rodney Reed would not be on death row had there not been racial bias in his case.
Right. Well, definitely when we look at the people who have been exonerated in North Carolina, the majority of them are people of color. And in other categories too, where you think, well, maybe this group of people, you'd think there shouldn't be that many of them on death row anyway, because they're the most vulnerable. But the vast majority of intellectually disabled people who were sentenced to death, African American, people who were on death row at the time of the Supreme Court decision that said if you were a child under the age of 18 at the time of your crime, predominantly African American. The people who've gotten clemency in North Carolina, right? So the people have gone all the way through the system, as the opponents always say, we've had 39 judges and justices have reviewed this case, and 12 jurors, and everybody agrees that it's fair. And you have a governor stepping out, usually taking some political risk to grant clemency, 5 out of 5 people of color. And so, those are the cases on the margins that really shouldn't be the death cases. And when that's where we really see discrimination playing a role. But even our 4 cases that went to hearing in 2012, 2 of those involved shootings of law enforcement officers. So that's a case where you think, okay, there shouldn't be as much discrimination, right? Because you got enough non-racial aggravation in the case. And yet those cases also were very plagued by racial bias.
Right, and highly emotional cases as well.
Right.
Well, I want to thank you so much for taking the time to talk with us. Your information that you gave us is invaluable, and it means so much to us.